Welcome to Unit 3. We have spent time gathering your information and thinking about your people, and now we are ready to look at one of the most powerful tools in your estate planning toolkit, the trust. When many people hear the word trust, they immediately think of the 1%, vast fortunes, mahogany row offices, and trust fund babies. I want to start today by busting that myth once and for all. A trust is not just for the wealthy. It is a versatile tool anyone can use to create an easy path for loved ones and maintain control, even during a detour like incapacity. The question isn't necessarily about wealth. It is about what tools are a good fit for your situation. To understand what a trust is, we need to look past the thick stack of legal papers. In its simplest form, a trust is not a magic document. It is a legal relationship. Think of it as a specialized contract for care. Let's use an analogy that makes this easy to visualize. Imagine the Batcave. In many comic books, an ordinary person enters a special place, like the Batcave or a payphone, and comes out as a superhero with a new identity and, very often, superpowers. A trust works like that. When you take ordinary property from your estate, like your house or a bank account, and you place it into a trust, that property follows a different set of rules. Same stuff. New powers. It takes on a sort of new identity and is bestowed with what we might call superpowers, such as resistance to probate, protection during your final journey, and in certain situations, some trusts may help with tax planning. In each of these situations, it is still your house, but because it is now wearing the costume of the trust, it can do things that aren't possible for property held in your own name. In plain English, a trust is a legal relationship where property is held and managed by one person for the benefit of someone else, following a set of rules. To create a trust, you need 7 basic ingredients for a trust to be valid and successful. First, you need the person setting up the trust. That's you. In the legal world, you're known as the grantor, though you may sometimes hear terms like settler or truster. If it helps, notice that each of these words ends with the letters O and R. That's your clue. The or is the person who starts the trust, the creator, the author. This is the person who decides the rules. Second, you need a reason or an objective. You aren't just setting this up for fun. You might want to avoid the hassles of the probate court, or reduce tax liability, or protect your property so it stays in the family for generations. Third, you need the trust agreement itself. This is the written rule book that spells out exactly how you want things to be handled. Without these rules in writing, a court may consider it no trust at all, and your property could be handled by default state laws instead of your own voice. Fourth, you need something that belongs to the trust. In other words, the property you decide to place inside. In legal circles, this property is formally known as the corpus or the trust principal. It may include your home, your investments, or even a life insurance policy. Fifth, you need a beneficiary. This is the person or group meant to benefit from what's in the trust. Sometimes that's someone else. Sometimes it's you. Sometimes it's both. Sometimes it is one person who receives a benefit for a time, followed by another who eventually receives the property. We will discuss different arrangements in later lessons. Sixth, you need a manager. Someone to watch over and manage the property now that it's in the trust. This person is known as the trustee. The trustee has a legal interest in managing the property, but they don't own it for themselves. Think of the trustee as the one holding the keys to the Batcave. They don't own the stuff for themselves. They are responsible for managing it properly. Finally, the 7th ingredient is the set of rules that tells the trustee exactly what they can and cannot do. Can they sell the house? Can they use the money for a child's medical emergency? Can they invest in the stock market? All of this is defined in your trust roadmap. Now here's something important. One person can fill more than one role. In many common trusts, the grantor, trustee, and beneficiary may all be the same person at first. That doesn't break the system. It may be one reason the trust was created in the first place. So, why do trusts exist at all? Trusts exist because sometimes people want rules to last longer than a moment, longer than a signature, longer than a single decision. A trust lets you say, I want this property handled this way, under these conditions, by this person, for these people. The power of a trust is that it helps take uncertainty out of a situation. If you were to pass away with only a will, your family might have to wait months or years for a court to approve the process before they can access your savings. But with a fully funded trust, the assets could move to your heirs immediately and privately, without a single day of court delay or a single public record. Furthermore, a trust could protect you while you are still here. If you were to face a sudden health crisis and become incapacitated, your trustee could step in instantly to manage your finances and pay your bills according to your rules. Without a trust, your family might have to go to court just to get permission to use your own money for your care. Now let's talk about what actually changes when assets enter a trust, because this is where confusion usually shows up. When you place property into a trust, the ownership changes. Not emotionally, not practically in your day-to-day life, legally. The property is now trust property, it is owned by the trust. Same house, same money, different legal wrapper. That's the Batcave effect. Once property is in the trust, it follows the trust rules instead of default rules. That may mean different handling during incapacity or after death, different timing or control. The rules are now the rules that you have created. It does not automatically mean taxes disappear. It does not automatically mean protection from everything. Trusts are powerful, but they're specific. The benefits depend on the type of trust and how it's used. And here's something especially important as we discuss powers of attorney and advanced medical directives in future units. A trust interacts in a special way in times of incapacity. A trustee manages trust-owned assets automatically under the rules you set. That may reduce friction during incapacity because the authority comes from ownership, not permission. That's not better or worse. It's different. And it's one reason trusts exist alongside other planning tools. By watching this video today, you now understand that a trust is a relationship designed for protection and control. You know that you are the architect and you are building a system that turns ordinary assets into a protected legacy. If you are ready for a small, immediate step, I invite you to think about the people you want to involve in your trust. Who would you choose to be your trustee? The person you trust to follow your rules? And who would be your beneficiaries? The people you want to benefit from your hard work. And if you want to go deeper, there are tools that can help you organize your assets, reflect on your goals, and understand how different trust structures may work at a high level, including how state rules can vary. Trusts don't have to be intimidating. They're simply a way to create clarity, structure, and continuity when you want rules to last longer than you.